And welcome back here to Live Now from Fox. I'm Andrew Kraft. Our next top headline takes us to the Windy City, Chicago. Live picture there, nighttime skyline view. This is what we know, according to the Chicago Tribune. Take a look at this. I want to update you on this case. Familiarize yourself with it. We know now that the Cook County State's Attorney's Office has declined to file charges against Chicago police officers who fired dozens of shots at Dexter Reed in a shooting that roiled the city and drew scrutiny to police policies around traffic stops. So this is what we know. The Cook County State Attorney's Office saying they will not charge any Chicago police officers involved in the fatal shooting of Dexter Reed. He was killed during a West Side traffic stop that escalated into a gunfight back in 2024 last year. Reed, 26 at the time, he was shot at least 13 times back in March of 2024 after he fired at an officer, wounding that officer in the wrist. Now, that's according to the Civilian Office of Police Accountability here. So we did hear from Cook County State Attorney's officials there from the prosecutor's office announcing this decision, declining to charge any of the officers involved in this deadly traffic stop. Let's listen.
We do know that there were 7 through-and-through gunshot wounds, and there were 6 lodged bullets from this shooting incident. His cause of death was multiple gunshot wounds, and the manner was homicide, which is defined as a death caused by another. The medical examiner recovered 7 bullets during the autopsy. Forensic examination revealed that 4 of them matched Officer Spanos' gun, 2 matched Officer Pacheco's gun, and 1 was from an unrelated domestic incident that occurred on August 25th of 2021, which also resulted in the use of a prosthetic left eye. In addition to all the records and materials that we received from the Chicago Police, from COPA, and from the Illinois State Police, we also took some additional steps to do a thorough investigation in this matter. We requested some additional forensic testing to be done. We asked the lab to examine the bullets and fragments, and they determined that there were 3 bullets and fragments that were a possible match to Reed's weapon. That additional testing, which ultimately resulted in one of the bullets matching Reed's weapon, was completed in February of 2025. We also put together the multi-cam video comparison. As mentioned, we have a state's attorney investigator who's a certified Axon investigate examiner, and we did that so that we could try to get the perspective of what all the officers were seeing and hearing as it happened simultaneously rather than looking at them one at a time. We also did what we refer to as their voluntary protected interviews. We refer to them as VPIs. The reason we do this is because every individual has a constitutional right to remain silent and protect themselves against self-incrimination. Chicago police officers, however, are required to be interviewed by COPA investigators and provide a compelled statement that is not voluntary. In Garrity versus New Jersey, the United States Supreme Court held that those types of compelled statements cannot be used against targets in a criminal prosecution, meaning we would not be able to review those compelled statements for purposes of our review. So in this case, the 4 shooting officers volunteered to provide statements during an interview with Cook County State's Attorney's Office personnel. And in exchange, those statements cannot be used against them for a criminal prosecution. But it did allow us to get a better understanding of their perspective of the incident. So we conducted interviews of the 4 shooting officers, Officer Giampapa, Pacheco, Webb, and Spanos. We did not re-interview Officer St. Louis because he had previously given statements to both IRT detectives as well as COPA, and because he was not a shooting officer, it was not protected. We were able to review those interviews. During the voluntary protected interviews, the information we learned was that the traffic stop was for a seatbelt violation, that the officers described Reed as leaning forward. They could not see his hands. They knew that the initial shots were fired by Reed, and multiple officers knew that Officer St. Louis was shot. The officers described that crouching position as Reed emerged between his vehicle and the police vehicle, and that they could not see his hands. Multiple officers also perceived Reed coming right toward them after he exited the vehicle, and the officers believed that Reed was still a threat while he was on the ground. So now we can talk about the applicable statutes that we look at when reviewing these types of cases. First is first-degree murder, which states that a person who kills an individual without lawful justification, those are the key words that we have to look at, commits first-degree murder if in performing acts which cause the death, he or she either intends to kill or do great bodily harm to that individual or another, or knows that such acts will cause death to that individual or another. We also look at the peace officer use of force in making an arrest. This language was amended by the Safety Act, and that statute states that a peace officer is justified in using force likely to cause death or great bodily harm only when he reasonably believes, based on the totality of the circumstances, that such force is necessary to prevent death or great bodily harm to himself or such other person, or when he reasonably believes, based on the totality of the circumstances, both that such force is necessary to prevent the arrest from being defeated by resistance or escape, and the officer reasonably believes that the person to be arrested is likely to cause great bodily harm to another, and that the person to be arrested committed or attempted a forcible felony, which involves the infliction or threatened infliction of great bodily harm, or is attempting to escape by use of a deadly weapon unless arrested without delay. We also look at the officer's use of force in making an arrest, which further states that a peace officer is not justified in using force likely to cause death or great bodily harm when there is no longer an imminent threat of great bodily harm to the officer or another. We also looked at the second-degree murder statute, and one important note to understand about second-degree murder is that it is a defense against first-degree murder. So we get to that analysis only if we could prove first-degree murder. We would have to prove beyond a reasonable doubt, which is our standard in all criminal cases, each element of the first-degree murder, including the element of proving the actions were done without lawful justification. So the same evidence is used in evaluating both first and second-degree murder. We also look to Illinois case law, which further establishes in People v. Parker that the law does not charge a person when he has reasonable grounds to believe himself in apparent danger of losing his life or suffering great bodily injury to use an inerrable judgment. It would be unreasonable to require such an exacting decision to be made in the space of a few seconds while one is fearful and under great stress. The United States Supreme Court has also held in a case, Graham v. Connor, the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. The calculus of the reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. The Graham court went on to say that courts must pay careful attention to the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. Another Supreme Court case, Tennessee v. Gardner, the United States Supreme Court has expressly held that if the suspect threatens the officer with a weapon or there is probable cause to believe that he has committed a crime involving the infliction or threatened infliction of serious physical harm, deadly force may be used if necessary to prevent escape, and if, where feasible, some warning has been given. So when taking the statutes and the case law into account, to be justified in the use of deadly force by an officer within the state of Illinois, it requires a reasonable belief that force is necessary to protect themselves or others from death or great bodily harm, and that the reasonable belief is judged against a totality of the circumstances. And that analysis of the reasonableness account for split-second decisions made under tremendous stress.
All right, so you hear their prosecutors leveling their rationale for why they declined to charge the officers involved in this fatal traffic stop there of 26-year-old Dexter Reed back in March of 2024. Back out live there to the Windy City. Well, our friend and colleague here at LiveNOW, Fox 32 reporter in Chicago, Casey Cronus, she has an extended look at this whole story. Let's watch.
In March of last year, the police shooting of Dexter Reed drew widespread attention when more than 100 rounds were exchanged after a traffic stop on the city's west side.
In this case, the evidence is clear and overwhelming.
After months of reviewing video evidence frame by frame, Cook County State's Attorney Eileen O'Neill Burke has announced the 5 officers involved did not commit any crimes.
It is unmistakable that Mr. Reed was the first to fire his weapon, a gun he did not legally possess.
Officers had pulled Reed over for an alleged seatbelt violation. He was asked to roll down his windows and show his hands, but officials say he didn't comply and opened fire instead.
Open the door! The evidence also shows that after an 8-second pause, Mr. Reed again engaged in a second round of gunfire.
The entire encounter took place in a little more than 1 minute.
4 officers fired a total of 96 rounds.
There were 11 fired cartridge cases found at the scene that were sent for ballistics examination to the State Police Crime Lab, and they all matched Reed's firearm.
Officer Gregory St. Louis never fired his weapon after being struck in the arm by Reed.
What happened that evening was a tragedy. A young life ended, a police officer was shot, an entire neighborhood was traumatized.
Andrew M. Stroth, the attorney representing Reed's family, tells me they are disappointed but not surprised by the decision and says the root of the problem is why Reed was stopped in the first place.
He got stopped from our perspective because he was driving while black by a group of tactical officers who have a pattern and practice of stopping individuals in the 11th District.
Stroth says he will be amending their federal civil rights lawsuit and will continue to pursue justice for Reed through the courts.
Well, this is a 26-year-old man who had a family who loved him and deserved to live his life, and that was cut short by the unconstitutional actions of these officers.
All right, back on live there to Chicago. We thank Fox 32's Casey Cronus for putting that together with a recap of how we got here to that decision today.